Oh, I see. Oh, yeah. Why not Alec? Yeah, do that. Thank you, Alec. So because we have some time, we're going to take it in an agenda item from tomorrow and hear it today. And the item is, it's a presentation on the new GR 12.2. And we have former Governor Alex Stevens, who is going to present to us. Welcome, Alec.
So a lot of what I'm going to be speaking on is, I think, starts on page 524. But this is about the presentation on the new GR 12.2. Just to give a little background, in 2020, in response to the racial reckoning, George Floyd and the Black Lives Matter issues, the state Supreme Court issued its letter on June 4th, 2020. And the BOG then created the Equity and Disparity Work Group. And that was after a proposal from then President Rajiv Majumdar. The work group was tasked with reviewing rules, regulations, and laws related to the practice of law and administration of justice to identify ones that impede real justice and fairness. And it also was to propose solutions that mitigate harm caused by unjust rules and procedures to go before the BOG. And you will find that on page 524. Today, I'm here to report on final action on the recommended change to GR 12.2 C2, which read in its pertinent part, C, activities not authorized. 2, take positions on political or social issues which do not relate to affect the practice of law or administration of justice. The work group proposed and the BOG adopted the proposed change that would read, activities not authorized, take actions which do not relate to or affect the objectives of GR 12.1 or GR 12.2A or B. Just to give you a little bit more background, the original 12.2C2 was talking about taking positions on political or social issues. And the problem there was political and social issues became a matter of opinion, not really rooted in anything necessary. And so at times, the Board of Governors would approve certain actions and disapprove other actions. And at least when I first came into being active with the civil rights law section, I began to wonder, well, what does the civil rights law section get to do? Since just about anything we might do would especially be considered political and maybe social. And that was the problem. And people would object and say, we're not going to do it because that's political. And then the Board of Governors would take up other actions. And I don't want to necessarily just call this one out, but hearing that, we actually voted, or they voted, I wasn't there then, to support marriage equality, which I personally agree with. But I couldn't understand, wait a minute, you say you're not going to take up political or social issues, but then you take up political or social issues. And it was very hard to get clarity, even from, and these are fights that I would have as chair of the Civil Rights Law section. So I'd say, okay, can you show me, can you give me memos that the board has passed that would give someone information on, what are the magic words, or what is the approach that will work versus the approach that wouldn't work? And in too many instances, the response I got back was, well, that's attorney-client, because this was general counsel advising the Board of Governors. And so we would flail and thrash. So the change that was made um, is to point to the GRs and those activities that are authorized. And that would then tell sections or other entities, if you want to take these actions, you need to show us the GRs under which you're going to move these actions. What is the support in the existing GRs? The Board of Governors voted then to support advancing the proposed changes. And you will see on pages 538 and 540 a number of the GRs that are highlighted, but those are highlighted by me, but it was just to point out here are a number of GRs that would allow us to do certain things. And this would certainly still require, since we had the conversation regarding the legislative committee, for example, that when we were coming forward, one would have to actually identify what the authority is that we're going to use to move forward. Like I said, the Board of Governors then passed that, and it went to the Supreme Court for its consideration. And it went to the Supreme Court in 2023, or it was passed by the Board of Governors in 2023. On June 5th of this year, the Supreme Court ordered the change to the GR 12.2, which is in effect. It went in effect September 1st with the changes that I mentioned. And you can find that order on pages 541 to 543. I think this is going to be a great change, but it also will allow, for example, the legislative committee and Sanjay and others to actually give direction and more specific direction when people are putting together their proposals to seek Board of Governor approval to move forward, that you're going to need to identify what GRs specifically apply to the action that you're advancing. Now, that still doesn't mean that the Board of Governors will or will not, but at least those who are putting together that proposal will know, what they have to do. In your materials also, I just wanted to point out the members of the Equity and Disparity Work Group are listed on pages 544 and 545. And you will see it is a group representing a cross-section of WISBA. Sections, councils, committees, parts of the Board of Governors, parts of the staff. I want to personally thank the leadership of former President Majumdar, who advanced the creation and constituting the work group. And I thank him personally for actually doing me the honor of appointing me chair of that work group. And I want to acknowledge Kim Sander, who was one of the subcommittee members, but her work was done a lot sooner than the work on 12.2C. And especially also, of course, the great staff that made sure this was moving forward through the process for the Supreme Court. Thank you, Tara and staff. And I want to also acknowledge the leadership of Laura Sierra who actually did a whole lot of the writing and the analysis that you will find on pages 531 through 537 that gave the baseline for us going forward. This is now in the GRs. And I'm very proud to have been a part of that, and I think it will give a number of our parts of the board of WISBA as well as in the Board of Governors some specific items to hang their hat on when we're being asked to take up a particular issue. That's it. That it?
So just a quick question, just because I'm not as familiar, because the story you've told is a long story. And so I do not have the benefit of that period of time. For me, and I also agree to where you're trying to steer the boat in regards to the DEI committee and trying to improve things. My only question is in regards to section 12(2)(b). It's a list of specific activities that is, it says it may do that. So it's a very specific list and it's there. List 12 things or 12 or 8, 22 things. It feels to me counterproductive legally to have an exclusion that says, well, if it's not in the list, you're not supposed to be doing it. To me, the logic of section C2 was to have a different breadth than the enumerated list on purpose, to go outside the purpose of these 22 things. So I'm just struggling with the logic of excluding, taking exclusive language that harps back to the provision, because I think it's already it's there in the provision. So it's kind of like, you see where I'm going with that.
I see where you're going, but let me also take you back. Before we actually identified and said, go back to those things that you can do. Okay. What the prior section said was, you can't do things that are political or social. Even though the GRs were there, but you can't do anything that's political or social. And then it becomes a matter of who decides based on what, and that was at least a part of the problem. In fact, I had queried when I was chair of the Civil Rights Law section, I was looking for precedential, guidance, and there was none to be had. And so it was almost as if, in terms of defining political or social as no-nos, it depended on what Board of Governors were around, what they decided in their discussions, oftentimes being in executive session, and then coming out and saying that, giving a yes or a no.
But section 1 has the same language in regards to foreign states or Canada, let's say Canada.
Yeah.
And that we're not changing.
Right.
What's the difference?
It would
here in
not change
scope?
it.
Are we able to, we're excluding something in the US, but we're not excluding it abroad? It's just the logic here.
Well, I don't think we can get into what happens in Canada.
Just, thank you.
Okay.
Anything else? And former governor and parliamentarian Stevens,
Okay.
I want to really thank you for this presentation. It actually is great to get an update, or actually to be reminded of what happened a few years ago that, kind of fell off our radar, it would seem, but it didn't fall off the court's radar, and that's all
Right.
that matters.
And now the next steps, for example, for the Legislative Action Committee
Yeah.
We'll be applying that
Absolutely.
for, I think, our template that
Yep.
tells people where to go. I mean, we'll now be able to give a lot more specific guidance.
It's going to be of great assistance, I think, to our committees moving on. We have Justice Yu here, and I know, hello, Justice Yu, yay. We're going to take a really quick break because we want to set up and have Justice Yu administer the oaths, and so don't go far, or else.